7, 2024, 1:30, Slade, Thursday. Bond with its conditions will continue. Thank you. Yes.
Report the note in my file from the other APA that you saw in violation you guys today.
Yes.
I have the May 17th, 2024 bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir. I was told I needed a court order, and I was on video Zoom with you on my last court order, and nobody contacted me and told me where to go.
Why didn't they?
I do have information about a facility that he would like to test at. He lived in Macomb County. We
I'm on GPS. Oh,
called them and they indicated as long as the order indicates what sort of panel needs testing and the frequency.
Well, that was supposed to be done before. If I give you a test today, are you going to test?
Yeah, the only thing I'm going to fail for would be marijuana.
Why are you using that?
Can I speak freely?
Yes.
Your Honor, I'm going to be upfront honest with you. I used to have a crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. And there's no excuses. It's just the only thing that I've helped to.
Give me an order. Okay, he's going to go over to community corrections test today. I'll get the results and then I'll determine what his bond will be as he proceeds up, because he's told me what's going to happen, and then we'll figure out. In the meantime, counsel can prepare an order so that he can test in Macomb. Okay.
And then just to be clear for the record, the waiver is complete and we're only coming back on whether or not he'll be remanded.
Pardon?
The waiver's all set now?
Well, technically, no.
Got it.
Because technically to retain jurisdiction, but I still have jurisdiction anyway. So he needs to go over and test, and then we'll figure out what we're going to do.
Okay. Thank you.
Thank you.
Oh boy. It's gonna be that day. What's wrong?
I just bring surprises.
Yeah.
Is that file still in the courtroom?
Pardon?
Is that file still in the courtroom?
I'm sitting here right with me.
We could recall it whenever you have the opportunity. That'd be wonderful.
I want a court recalls case. People versus Revokes.
Thank you, Your Honor. Nicole, who's on behalf of the people?
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
As we were walking out of the courtroom, I went to release the deputy who was present. I did not believe that the victim of the domestic violence was present today because she didn't check in with us. As we were leaving, the deputy let me know that the victim was actually present today with the defendant sitting beside him. As we exited into the hallway so that I could see who the deputy was referring to, the defendant was speaking to Ms. Perkins out in the hallway, and the deputy confirmed that that is the victim. There, as I understand it, based on everything that's filed, there's no contact order. So in that, in addition to the corrections violation, I'm requesting that he be remanded and that his bond be revoked.
That's not my problem.
Mr. Allen, thank you, sir.
Your Honor, I have no further information at this time.
Does he admit to the violation?
You're right. That's right.
If you wish.
She wasn't here with me today, Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway. We were talking to her about testing, and I said something that I didn't.
Were you sitting next to each other in the courtroom? I can get video from the courtroom.
Okay, I
So-
understand that. Yeah, she was sitting next to me.
You're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded. It'll just go up before Judge Slay. I'll just leave it there.
Thank you.
Your Honor. Yeah.
Your Honor, he was here.
Oh, man.
Oh, no.
And- Well, let me, let's just say this is a similar situation to one you had about 3 cases ago. where he was going to be sent across the street.
And so he,
Proactively went and did it on his own.
Oh, I think absolutely, yeah, no question.
so he's not here.
Well, let me go out in the hallway and see. He was here because I.
Go ahead, you can check away. It's just one of those days.
I think he's over there testing away.
Do you think so? Okay, I love the faith that Mr. Childers has in people. Oh, I think he's gone. I think maybe at the nearest beach he could find. He is gone. But his attorney stayed.
I stuck around.
Yeah, I know.
He's not, he's gone. David I. Goldstein to bring on behalf of the defendant. Yeah, I told him there was a community corrections violation, discussed it. I asked him if he was going to test dirty. He said probably for marijuana. So.
So for marijuana, he left. Yeah. Preliminary examination being set. Defendant having failed to appear, bench warrant will issue for the defendant's failure to appear. I will indicate defendant was here and then left. Will issue immediately, no bond.
Protesters, maybe he's.
No, Mr. Childers, leave it alone. Yeah, maybe a lot of things happen. Right.
Okay. The file for Mr. Howard Smith's gone?
Oh, yeah. Why?
Because I just got a text from him.
He's testing?
I don't want it texting. Not sexting, texting.
Thanks for clearing that up. Okay, you got a text?
Your Honor.
Yes. Hold on.
The courtroom hearing begins with a routine review of a bond violation report dated May 17, 2024. The judge questions the defendant about a missed drug test that was required under the conditions of his bond. According to the defendant, he was told he needed a court order to complete testing at a different facility. Because of that confusion, he claims he never received clear instructions about where he was supposed to report. The defense attorney confirms that a testing facility in Monroe County had been contacted and that they were willing to conduct the required testing as long as the court order clearly specified the testing panel and the frequency of the drug screens. However, the judge points out that this issue should have been resolved earlier and asks the defendant a direct question: if he were tested immediately, would the result be clean? In a surprisingly honest moment, the defendant admits that the only substance he would likely test positive for is marijuana. He openly explains his personal struggles, revealing that he previously battled a crack cocaine addiction and claims to have come a long way in his recovery. He also shares that he has recently experienced major personal losses, including the deaths of close family members. Though he acknowledges that these hardships are not excuses, the judge listens but decides that the matter requires immediate verification. The defendant is ordered to report to community corrections for a drug test the same day, after which the court will review the results and determine whether his bond conditions should remain in place or be modified. As the court moves forward with other matters, the case is briefly recalled when new information emerges involving another defendant. Mr. Ruggs, what initially seemed like a routine bond review, suddenly becomes far more serious. The prosecutor informs the court that a domestic violence victim was actually present in the courtroom earlier, something the court staff initially did not realize. According to a deputy, the victim had been sitting beside the defendant during the hearing, and the two were later seen speaking together in the hallway. This immediately raises a major problem. Under the defendant's bond conditions, he was strictly prohibited from having any contact with the alleged victim. The judge questions the defendant directly, asking whether he was speaking with her and whether they had been sitting together inside the courtroom. The defendant admits that they had been sitting next to each other and acknowledges briefly speaking with her in the hallway. That admission alone confirms a clear violation of the court's no contact order. Without hesitation, the judge issues a firm ruling. The defendant's bond is immediately revoked, and he is ordered remanded into custody. The case will now move forward under stricter conditions before the assigned judge. However, the courtroom drama doesn't end there. Shortly after the ruling, the court realizes that another defendant who had been present earlier may have quietly left the courthouse before completing his required testing. When court staff check the situation, it becomes clear that the defendant is no longer in the building. The judge reacts with visible frustration as the realization sets in. The defendant had been instructed to report for testing, but instead appears to have walked out of court entirely. As a result, the judge issues an immediate bench warrant for failure to appear, officially noting that the defendant had been present in court but left before completing the required steps. The warrant is issued with no bond, meaning the defendant will be taken directly into custody if located. By the end of the session, what began as a routine bond compliance hearing turns into a series of escalating courtroom problems, from missed drug testing and bond violations to prohibited contact with a victim and a defendant leaving court altogether. The hearing highlights how quickly courtroom proceedings can shift when defendants fail to follow court orders, reminding everyone involved that bond conditions are not optional and violating them can lead to immediate and serious consequences.